Thank you so much for coming to our February meeting on serving LGBT clients in our community. We are so fortunate to have a large panel today of 5 speakers to talk to us about recent changes in policy at the local, state, and federal level. They're also going to speak to us about significant case law and legislation in this area, and talk to us some about community-based services that we might be able to utilize or better utilize to assist our clients. So we are so happy to present our 5 speakers: Kara Engelhardt, who is a law fellow at Lambda Legal; John Knight, who's the director of the LGBT and HIV projects at the ACLU of Illinois; Lark Mulligan, an Equal Justice Works fellow at Cabrini Green Legal Aid; Maria Paul, trans legal director and staff attorney at Trans Life Center Chicago House; and finally Mike Ziri, director of public policy at Equality Illinois. So thank you so much for being with us, and I'm going to let you take it away. Oh, and also don't forget to sign in for CLE.
Do we have a... We're starting first. I'm not really sure that we set that up.
I don't know.
So,
I think we agreed to go federal to local.
I thought if someone else would start.
I will start, and then I think it makes sense if you went next to talk about federal.
Okay, that's wonderful.
Okay.
Thank you.
Good afternoon. I'm Kara Engelhardt. I'm a law fellow at Lambda Legal. I am here afterwards if you have any more questions following our question portion. We're going to do an overview of LGBT emerging issues, starting with federal level issues, then state and local. Federally, Lambda Legal is working on, well, we are a national organization, so a lot of our work is federal. Most recently, something I'd like to talk to you about is the Health and Human Services new regulation protecting statutory conscience rights in healthcare delegations of authority, one day after announcing its creation of the Conscience and Religious Freedom Group. That was just late last month. The new rule allows for people to refuse to serve or to provide healthcare services to people based on religious reasons or their own morality. It's very broad sweeping. It allows healthcare providers to refuse and maintain their federal funds, even if this discrimination flies in the face of federal laws and regulations. It is so broad sweeping that it also could permit, it is so broad sweeping that it also could permit conversion therapy. But luckily, thanks to great work of other people on this panel, conversion therapy is banned in the state of Illinois. Additionally, on the federal level, Lambda Legal is involved in the lead on a lawsuit called Karnofsky v. Trump, which is a challenge to the transgender military ban that was originally tweeted on July 26th. There are 3 other similar lawsuits across the country. John may also be able to tell you about the ACLU suit. But all of the suits have been successful in pushing back the ban from going into effect during the course of the litigation. We've all had successful preliminary injunctions. Lambda Legal represents 9 individuals and 3 organizations, including the HRC, AMPA, and a local organization, the Gender Justice League in Seattle. That's where our case is in Seattle. We moved for summary judgment just at the end of last month, so we're really hopeful that the court can understand that all of the facts are out there, because there really aren't that many facts. This was just a tweet that came from nowhere, and there was already good science indicating and supporting an inclusive policy. Let's see what else is happening. Okay, and so then a little closer to home, just last April, we had a successful suit here in the 7th Circuit, Hively v. Ivy Tech. Kimberly Hively was a professor at Ivy Tech. She was fired because she's a lesbian. We filed suit under Title VII, and we were successful. First, the 7th Circuit held on to some bad law and said that they couldn't rule in our favor because of some precedent. But then we petitioned for an en banc panel, and in an 8-3 decision written by Judge Wood, we got a beautiful decision that said that Title VII protects against discrimination based on sexual orientation, specifically that discrimination on the basis of sexual orientation is like a form of sex-based discrimination because it's discrimination based on sexual stereotyping. And I can read a quote here, which I think is beautiful. Hively represents the ultimate case of failure to conform to the female stereotype, at least as understood in a place such as modern America, which views heterosexuality as the norm and other forms of sexuality as exceptional. She is not heterosexual. Our panel described the line between a gender nonconformity claim and one based on sexual orientation as gossamer thin. We conclude that it does not exist at all. Hively's claim is no different from the claims brought by women who were rejected for jobs in traditionally male workplaces such as fire departments, construction, and policing. The employers in those cases were policing the boundaries of what jobs or behaviors they found acceptable for a woman, or in some cases for a man. Similarly, we had a case, Evans, in the 11th Circuit, where we lost, and so there's a circuit split. And we petitioned for the Supreme Court to take up the case, and we were unsuccessful, so there remains a circuit split. But cases in the 7th Circuit are protected, and other federal courts, lower-level federal courts, have found that Title VII protects from discrimination based on sexual orientation. And finally, just Tuesday, we had what I thought was a fabulous oral argument at the 7th Circuit on behalf of a woman named Marcia Wetzel. She is a senior who was living in a place called Glen St. Andrews Living Center. It was out in the suburbs. She had been repeatedly verbally and physically harassed because of her sexual orientation. There's a specific other tenant at this facility named Bob Herr. He just very much disliked Marcia because of her sexual orientation and the fact that she lived her life with a woman and raised a child with her partner. Marcia actually lived in this facility because Judy and her wife, or not her wife, her partner Judy, they were never married. And when her partner died, her partner's family took the house that was in Judy's name. And so Marcia was evicted, and she now is on government assistance and is no longer at Glen St. Andrews. We have her in a much better facility up in Wrigleyville. She's just bummed because she's a huge White Sox fan. And she, for the first time in her life, has a community of LGBT peers. So she really likes it there. But we argued that the Fair Housing Act should protect people from discrimination based on their sexual orientation. And we were dismissed at the lower court, not even considering the sexual orientation claims, just that landlords aren't liable for violence and discrimination caused by their tenants. But we argue that it creates a hostile living environment in the same way that Title VII protects against hostile working environment claims, because Title VII we read the Fair Housing Act in the same way that we read Title VII. So we had a great argument in front of Hamilton and Obama appointee Judge Wood, who wrote Hively, and Caney on Tuesday, and we think that went fairly well. In fact, opposing counsel, who argued that landlords aren't responsible for any kind of discrimination, even if it's racially based discrimination, because people have the ability to call the police, did concede that Hively was correctly decided. So we'll see what happens in that case. And that's a wrap for Lambda's work on the federal level.
Great. I guess I'm going next, and I find that it's a little hard for me to decide what's federal and what's state level, so I'll do my best with respect to that. The ACLU, although I work for the ACLU of Illinois, I also have a position as a senior staff attorney for the National LGBT Project of the ACLU, and work with colleagues in other ACLU affiliates. So the ACLU has affiliates in every state and does lobbying as well as legislation in every state, and then nationally we have a national legislative office. I say that because it means we're, to some degree, we try to know exactly what the ACLU is doing, but we're a little bit siloed, so I can't speak with the same level of authority about our legislative work in DC. But I will try to tell you about what I know in terms of LGBT-related work with respect to changes with respect to national policies, for example. So what I thought I would talk about, I'll mention, yes, the ACLU has a challenge called Stone versus Trump to the military ban. The only thing I would add to what Kara said about that is that there is, there's supposed to be a DOD memo that's going to come out soon. It's a little bit unclear because it sounds like that memo won't, in fact, support a continued exclusion, although I understand there's some difference with respect to existing people who are already in the military versus those who will want to apply or enlist in the future. So, I'm sure it will be interesting because it's not entirely clear that Trump will actually approve of what comes out from DOD, since I'm not sure they're of one mind with respect to that. What I thought I would talk more about, though, is the Trump treatment of students who are transgender. As many of you may know, there was a memo that came out from the U.S. Department of Education under Obama, which has been quickly retracted by the new administration, and that has an impact on us. Now, there's some confusion. I think the fact was that was a memo interpreting federal law called Title IX, which prohibits sex discrimination, and that has been interpreted to cover transgender students as well. So, Title IX is still there, it hasn't changed. So, that's terrible, but it hasn't changed. It's terrible, and I have a sort of first-hand experience with that. I represented a student in the northwest suburbs who filed a complaint against the U.S. Department of Education several years ago, and I don't have exact dates, but she, we were ultimately took a while to do the investigation of it. The issue was that my client had been told she couldn't use the girls' locker rooms. She was told she had to dress in a private area. She was told it's fine to use the girls' restrooms, but locker room, no, can't do that. And that had serious problems for my client. It was embarrassing to be singled out. No student, think about young people. I mean, no student wants to be singled out as different and told she's not really a girl, which effectively is the way that it communicates to her. So the ED found a violation. When it came down to it, the district offered a arrangement that, yes, my client could be in the girls' locker room, but only if she agreed to dress in these private areas that they had built within the locker room. In general, we agree privacy is a great thing, but that no student should be discriminated against. And so, unless they're going to tell all students that they have to dress in these private areas, that's wrong. The Department of Education agreed. So there was a resolution agreement that we could all say has some problems in clarity. We always, and the Department of Education said that doesn't allow them to require my client to do something different from the other students, but the district just interpreted it differently and went ahead and did that. So that brings us to a related issue of a case that we've got going now. We've represented a number of transgender students the ACLU has nationally, either in federal or in state court. I have some cases under the State Human Rights Act. As you know, we're lucky to be in a state that prohibits discrimination against transgender people, including students. And my client said, I don't like that arrangement. I don't want to face that kind of discrimination. So we filed a lawsuit in November under state law, arguing that that violated the Human Rights Act. The judge, unfortunately, read the law in a very strange way and decided that, in fact, what the schools had to do was only give people access to facilities, which would include a cafeteria or any number of facilities. They didn't have to treat them the same with respect to their use of the facilities. They just had to let them in, basically, which is, frankly, a very strange ruling. So we are appealing that ruling, and are hoping to be successful ultimately in proving that schools can't do this sort of strange thing of treating students unfairly. The reality is that particular district has been subject to all kinds of litigation. There's a federal case moving forward now in which some parents complained about my student having even that kind of limited access, and some students, and they asked for a preliminary injunction, which the magistrate denied, and the federal district judge recently affirmed that denial. The plaintiffs had originally said they were going to appeal, but they have told us now they're not going to do so. On the other hand, there are cases the ACLU is involved in Pennsylvania, for example, which have been appealed to the Third Circuit. Same kind of situation in which the school was treating the students correctly, and different in the sense that the school didn't have this weird limitation about locker room usage, but that issue is being appealed to the Third Circuit. And so I've been talking for a while. Let me talk about a couple other things. I guess one thing I would just say about that is one of the reasons why we think it's important to ensure a robust interpretation of the State Human Rights Act is just that, frankly, we don't really know what's going to happen with federal law going forward. I mean, Trump has the ability to appoint judges. I don't know if you've been following it, but it's a little bit scary what's going to happen in the future. And so state protections are just really, really crucial. So, Mike and our other friends who are lobbying to protect protections for LGBT people have a really important job to do. So I wanted to mention one other area, and then we've got a lot of other people I'd love to hear from. There's a federal and sort of a state component to this, in which is many of you have heard of the Federal Affordable Care Act, of course, which is much in the news. There is a non-discrimination provision within it. There are regulations that have come out about it saying that when it comes to things like healthcare and Medicaid, that federal facilities or facilities that get federal funding must treat people equally. And that's, we thought that might mean an end to the many states that continue to have exclusions on fair healthcare treatment when it comes to people who are transgender. We don't really have quite the same hope. 1557, the regulations still exist, but I think there are definitely movement to change that rule and get it undone through a regulatory process, which would be terrible. So we have litigation in several states, and I've been working on a case for several years now in Iowa under Iowa state law, challenging the exclusion of care for transgender people, where they have a ban on coverage for surgery under the Medicaid law. And we hope to be successful there. And I think there are other issues to talk about it, but I'd love to hear from other people. So.
Sure. I think I'll hop on next with state level stuff. My name's Mike Ziri. I'm the policy director at Equality Illinois. We're the state's civil rights organization for LGBTQ folks since 1991. And most of our focus in a policy space is at the state level. So a lot of lobbying, passing bills in Springfield, with some focus on state or federal legislation with our members of Congress and U.S. senators. I appreciate John talking about our lobbying work. We have great partnership with the groups at this table, ACLU in particular, who has a lobbying presence in Springfield as well, and we do great work together. Illinois has a great record of passing good laws for LGBTQ folks. And all of those bills have been passed with bipartisan support. So we have Republicans and Democrats coming together in Springfield, and sometimes Republican governors signing our bills. In the recent years, I would say the most noteworthy piece of legislation, in 2015, we were the third or fourth state to pass the conversion therapy ban. And since then, there's about 5 other states that have passed it, so it's about 9 or 10 states now that have passed a conversion therapy ban, which was important at the time in 2015, which I think is even more important now when you consider that our vice president is an advocate of conversion therapy. So it's important that we have those protections. Plus, our law also has an interesting part that most other states don't have, and that is someone can bring a claim under the consumer protection laws, saying that the marketing of conversion therapy could be consumer fraud, because you're saying that to be transgender or to be gay or bisexual or lesbian is a mental disorder that needs correction, which we know all the major mainstream medical organizations, that's not what they say. So that is an important piece of the Illinois law, and that's been in the book since 2015, took effect 2016. Last year, we continued our great progress with several different bills, two in particular. One I'll mention in depth and one I'll just briefly mention because I think Lark is going to talk more about that piece. But one is House Bill 1785, which passed last year. Took 2 years in the legislature, but I know there was a lot of work before that over years. And it's a bill that modernizes the state's birth certificate law so that a transgender person or an intersex person won't have to undergo surgery anymore, which had been the law since the 1950s. As you know, laws don't always keep pace with modern standards of care. So it was an important bill that we got passed thanks to the leadership of the folks at the ACLU and Lambda Legal and the AIDS Foundation, Quality Illinois, a lot of great organizations. And again, bipartisan support. Governor Rauner signed it, and it's actually, that bill has lately been making an appearance in a campaign ad, as you may know. But it's a good law, a very good law. I won't go into too much of the mechanics of it. But the other bill that got a lot of attention, even in the French press, was our bill to ban what's called the panic defense. Senate Bill 1761, passed unanimously. We think it was the first LGBTQ affirming bill in the country to pass with unanimous support in both chambers. And the background on this is, so the panic defense, you may or may not know, it's a tactic where a criminal defendant, in this case, in murder cases, may say, yes, I did that, I attacked that person, in this case I killed them, but I was provoked because I found out that they were gay, or I found out that they were trans, usually in the course of a romantic or sexual activity. These cases where this has been used are very few, but they're still shocking. And I think the most popular one to think about is probably Matthew Shepard, but there are a lot of other cases where this has been seen. So we looked at what's been done in Illinois, and we said, no, this is our sexual orientation and our community's gender identity should not be used as an excuse for provocation to kill us. So we were able to pass it. It took 2 years. Most of our bills do take 2 years. It take about a year of education of the legislators. But we were able to pass it last year. The governor signed it. Like I said, it's gotten a lot of attention, and now a lot of other states are looking at copying. I know Texas or Rhode Island. So those are some of the laws we saw last year. At the federal level, there's not a whole lot of legislation. Congress isn't doing a whole lot these days on anything, it seems, but really on LGBTQ issues. I think they're letting Trump and the administration drive the agenda, the animus there. But we have seen some good bills introduced. Congressman Schneider from Lake County and a Republican congressman from Virginia introduced a bipartisan bill to add sexual orientation to the fair housing law. That was last year. One bill that we've seen introduced previously, but not in this session of Congress, is what's called the First Amendment Defense Act, which would essentially establish a license to discriminate based on your religious belief, your so-called religious or moral belief. In the previous Congress, it was introduced by Senator Ted Cruz of Texas. We haven't seen it introduced now, and my only assumption for that is because we're seeing a lot of that so-called religious, religious liberty stuff coming out of the administration. So the need for a bill isn't so much there if you can get what you want out of federal agencies, as we've already heard. And then just a few of the things that we're focusing on. There is actually a bill It's not our initiative, but we were supportive of it. It was introduced just this week by State Representative Will Guzzardi to amend the Human Rights Act. The Human Rights Act, the employer threshold for employment non-discrimination applies to employers with 15 employees or more. Whereas if you look at the surrounding states who have similar laws, their laws are, Michigan and Minnesota, one or more employees. So Illinois law is, I think, a little out of sync, especially if you look at our partners. So Representative Guzzardi has introduced a bill to lower that threshold. His bill says one or more employees. There may be some negotiations involved with entities who are interested in employment issues. And that's House Bill 4572, if anyone's interested in that bill. And it was just introduced this week. And then just two other areas that we're looking at going forward at the state level. We're part of a broader discussion among groups about the HIV criminalization law here in Illinois. And also, we're developing a broader push to really get more LGBTQ people into public service, whether that means running for office or whether that means sitting on a state board or commission. Like the State Board of Education, as far as we know, has no LGBTQ people on it, yet it's a board that can develop policy around the fair treatment of students. So if you know anybody who's interested in public service who's LGBTQ, let us know, because when you have more LGBT people in public leadership roles, you have folks who can share our stories, tell our truths, and also be role models then as well. So that's some of what we're seeing at the state level. I don't want to talk terribly long, but I know we'll be around for questions. But I'll turn it over to our other great panelists.
Okay. Hi, I'm Maria Paul. I'm the legal director of the Trans Life Care Program at Chicago House and Social Service Agency. A lot of what I do is direct service, providing legal advice, legal information, and doing cases for our Chicago House transgender and gender nonconforming clients. We have a drop-in every Monday. If anybody is interested in sending clients to easily accessible holistic drop-ins. Our drop-in includes legal individuals, myself normally, who's there to give advice. We also have housing, healthcare, and a place to eat and shower and all that kind of stuff. So it's a drop-in center as well. So that's where I get a lot of my clients from that drop-in. I'm going to talk about specifically police interactions in the city of Chicago. Chicago Police Department does have a specific policy for interactions with transgender and gender nonconforming individuals. It was updated in 2012 and again in 2015. That directive is unfortunately still very internally contradictory and unclear. The specific section that is most problematic, and I left copies of this out on the table there if people want to get their own, but gender classification of arrestees, I'm just going to go ahead and read that. So an arrestee's gender will be classified as it appears on the individual's government-issued identification card first. The exception to that is if those arrests are arrests of individuals who are post-operative, which, as anyone who works with transgender individuals knows, there is no one particular surgery that any individual has. That it's, once again, a very private situation, but they are, right in the policy being asked that in the event a government-issued ID is not available, they have to know what the arrestee's genitals look like. This is problematic for a whole lot of reasons. And in particular, we just ended up having one of our peer outreach individuals. So we have folks who are in community who go out and do the outreach and tell people about the services we offer and everything like that. And we had one of our peer outreach individuals who he was actually on the clock out at night at a club to hand out condoms, hand out information, and he actually ended up getting arrested by police officers who were going along that beat. They put him in, he showed them his ID card. He explained to them what he was doing, that he worked with our organization. But he was still nonetheless arrested for reasons that are not very clear. He was taken to be processed and placed into an individual room and handcuffed to a chair where the door was open, and he was able to hear the entire time in the office all of the officers debating whether or not he was a man or a woman, debating whether he had a vagina or a penis, and trying to decide who should strip search him or who should pat him down. And this went on all night. They left him there. And so we filed an IPRA complaint around that. And as well, there is a Windy City Times article that I left out on the table that Malik, who is our peer outreach employee, spoke to Windy City Times and explained his experience. So unfortunately, even when they update the policies, it's obviously not doing good things for community when they get arrested. They're still being treated in a very dehumanizing fashion, and there still seems to be a lot of confusion amongst police officers what even a transgender individual, like what that is. What is gender identity? They all seem to be, going based on business as usual instead of trying to follow a non-discriminatory policy. So that's my big thing that I was talking about. I'll let Lark go next for local stuff.
Cool. Thanks. Hi, everyone. My name is Lark Mulligan, and I am a collective member at the Transformative Justice Law Project of Illinois, where we provide free holistic legal services for transgender people who are criminalized in Illinois. And I also have a 2-year fellowship hosted through Cabrini Green Legal Aid with advice and support from the Transformative Justice Law Project. I primarily do criminal defense and criminal records work for transgender people in Cook County. Right now, I primarily work on felony cases at 26th Street. A lot of my clients are incarcerated in Cook County Jail and in IDOC. And then I do some other related civil work, housing and family law type stuff. So really trying to do that holistic model, working with trans folks. And I am also myself a transgender woman. And so today I'm actually going to mostly be talking about identity documents and a little bit about how that intersects with the criminal legal system. I'm also happy to talk about things going on with Cook County Jail and what it's like to work with trans folks in those courtrooms at 26th Street. Got some stories. So, identity documents are incredibly important for trans people. I think we've all kind of mentioned that a little bit, but I just want to say that outright. We're living in this age of the war on terror, of hyper-surveillance by the state, particularly of poor people and people of color and people who immigrated here. Identity documents reflect gender markers, for one, and also names, which names are also very gendered in our society and in our culture. When a transgender person has an identity document, like an ID or a birth certificate, that has a name or a gender marker that doesn't, quote, match sort of what they're presenting or how other people are reading them, that can open that person up to extreme forms of violence and harassment and discrimination whenever they present that ID. Just think of all the times that you have to show your ID. It's necessary these days to access basic resources, to access school, employment, housing, government benefits, voting. I've known people who have had issues with voting in Cook County because of their IDs. And also, like Maria mentioned, CPD's policies currently are based on identity documents. And so all of this really plays a huge role for how trans people are treated when they're trying to access these resources or interacting with the police or in jail. Right now, just starting with basic name change law in Illinois, the law says that you have to, there's some residency requirements, live in Illinois for at least 6 months, There's a publication requirement of 8 weeks. I want to mention that the residency requirements, TJLP has done a lot of advocacy with the judges at the Daly Center in the past several years. Those residency requirements are being read as Illinois residency requirements and not United States residency requirements, meaning that a person can get a legal name change in Illinois, even if they're not a U.S. citizen. And we also have these criminal restrictions on name changes in Illinois. The law says that for anyone who has any felony conviction at all, then there is a 10-year waiting period to change their legal name, starting from the date that they terminated the sentence for that felony. And so that includes things like retail theft, felony prostitution, which used to be a felony and is no longer, thankfully. Any sort of like survival crimes that trans people are committing in order to get by can become barriers to changing their legal names, which then impacts all of these other areas when people try to access resources. And then there's also some misdemeanor and other felony convictions that create a permanent bar to changing your legal name in Illinois, which include identity theft and various sex crimes. The Transformative Justice Law Project hosts a monthly name change mobilization at the Daly Center. We've been doing this since 2010 and have changed over 800 names since then. We've really become the experts in Cook County on name change law and have done a lot of advocacy with the judges at Cook County to make the process more accessible. There used to be judges who were denying name changes because they didn't think it was a legitimate reason for a trans person to change their legal name. That's no longer the case, and now these hearings are running pretty smoothly. We're changing about 30 names plus per month these days. The Transformative Justice Law Project is also, we ran a test case challenging those felony restrictions because we believe that those are unconstitutional, an infringement on transgender people's First Amendment rights to freedom of expression through their name and their gender markers and their genders. We ran a test case of that. We made some statutory interpretation arguments, worked with the Illinois AG's office, and it didn't work. So we are continuing to work on that and preparing to mount full-on constitutional challenge to those. As you mentioned, the birth certificate law has also changed recently. I don't have much else to add to that. The only thing is that that surgery requirement that we used to have up until this past January was incredibly burdensome and incredibly prohibitive. Surgeries, like Maria said, there's no one surgery that trans people get. There's no such thing as SRS or sexual reassignment surgery. That's not real. What we have instead is a whole variety of surgical procedures that are available to trans people. Most of them are very expensive, not covered by any insurance, and a lot of trans people just don't want surgeries. I think it's less than 2% of transgender women ever get any sort of genital surgery. And so that surgery requirement was holding back a lot of trans folks from getting their gender markers changed on their birth certificates. The law now says does no longer require surgeries. It's more similar to what's required to change a gender marker on an Illinois state ID or driver's license. I believe the language is something like this person is undergoing clinically appropriate treatment under my care, written by a physician. So that's pretty vague, does not require surgeries or potentially even hormones or that kind of medical care. The last thing I want to mention is a new identity document coming out in Chicago pretty soon. It is called the City Key, Chicago City Key. This is a Chicago municipal identification card. They're currently in the pilot phase of this City Key, and it's expected to launch fully in March, I believe, or late spring. The Transformative Justice Law Project, and in particular my colleagues Tanvi Sheth and Monica James, worked very hard on this over the past couple of years to get this municipal ID ordinance passed. It is a great example of sort of coalition work and intersectional work because this city key benefits not only trans folks, but also folks who are undocumented, folks with disabilities, folks who are elderly, people who are getting out of jail and prison, anyone who's having, who might face some barriers or restrictions to getting an Illinois state ID. The requirements are a lot less burdensome. It's cheaper, things like that. It'll also double as a Ventra card and a library card. So 3 things of note for this that are important for trans folks. One is that it allows people to self-designate their gender markers on the ID, meaning that you don't need any sort of letter from a doctor saying, yes, this person is trans. You can just say, hey, I'm trans, and let me put the gender marker that I want to put on here. No proof needed. Among the options for gender markers, we have M for male, F for female, and NB for non-binary. And then also the option of not including any gender marker at all. Chicago is one of only a handful of jurisdictions in the country, in the world, I think, that allows these options outside of the traditional gender binary. The last thing I want to mention is the municipal ID also allows people to include their just first initial of their first name and then their full last name on the ID. We included that, we fought really hard to include that provision because we see that as a form of harm reduction, particularly for trans people who cannot change their names because of the felony restrictions. And so this allows them to put just the first initial of their first name so that they're not outed every time they present that ID to employers and so on. So those are some of the updates and identity documents. I think we're pushing up against time. Again, I'm happy to answer questions about criminal legal stuff in jail as well.
Okay.
The city key, this just shows that I don't know anything about identity documents. Will that be able to be used to establish like a birthday, like for with bars and I mean that's obvious, but for other types of
Yes. No, that's
but like for other, could it be used as a form of ID in any way that an Illinois state ID could?
Yeah, that's part of the rollout that's happening. Is doing all of these organizations that have worked on this municipal ID are going to continue to advocate with various offices around the city and employers and so forth to tell them, hey, this is a legitimate government-issued ID. This person's not just making it up. And so, yeah, and the bar thing is important. There was a case a few years ago of a transgender woman who went to a bar, I can't remember where, somewhere on the west side. She had not yet changed her name or gender marker, presented her ID to the bouncer in the front. They would not let her in because the bouncer, quote, did not know what bathroom she would use. And so she was outed in front of this entire line of patrons going into the bar, and people began shouting slurs, harassing this person until she had to leave for safety reasons. So even interactions like that many of us don't think about, like, oh, I gotta take out my ID to show you that I'm over 21, that can turn into a really dangerous situation for a trans person too. So, good question.
Any questions?
Can also add a little bit about working with trans people, I guess, if we still have time. So yeah, as I said, I work exclusively with trans and gender nonconforming folks. I've really been doing this work for over 10 years, primarily working with trans people in IDOC. I guess a couple things to note: if you are ever have the honor of working with a transgender client in any capacity, one is sort of the takeaway of what I'm talking about, identity documents. Names and pronouns are very important. Check in about names and pronouns often and check in about them in different contexts. I always ask my clients whenever we do an intake or first meeting, what name and pronoun do you want me to use while it's just us or within our office, in court, when I'm talking to your mom, when I'm talking to the staff at the jail, all of these, and I continue to check in about those before we enter any of those contexts because gender is fluid, pronouns can change. People can prefer different names in different contexts. Especially in the legal system, you know, court is very, very gendered, right? I think there's some jurisdictions where women are technically legally required to wear skirts or something to court, someone was telling me. I have actually entered a courtroom at 26th Street before, wearing a button-up collared shirt, and the judge yelled at me for not wearing a tie because he was reading me as a man, and wanted to kick me out of the courtroom because I wasn't appropriately dressed for court. And so these things are really important to think about, especially in these settings like jail and court that are just so antiquated in their gender rules. And as attorneys, we're taught to sort of like call everyone Mr. or Miss whatever, right? And so not everyone wants that. Just be aware of that. Some people do. Case captions are a big issue, right? If someone hasn't changed their legal name, it can be really traumatizing to have to go into court and hear, you know, the people of the state of Illinois versus this name that does not feel good for me to hear. You know, be aware also of if you have documents that have your client's legal name on them, even just that person seeing those documents on the table can be difficult and traumatizing for people, so be aware of that. I have done motions in court when other people in the court, like state's attorneys, are not respecting my client's gender pronouns, and you can file a motion to have people and everyone in the courtroom respect that person's pronouns. Yeah, that's a lot of the stuff I wanted to talk about. I think also keep in mind that you know, any time that a trans person is walking out into the world, we are vulnerable. So much can happen in between leaving the apartment or shelter, wherever, and getting to your office for a meeting. A lot of times people show up late, and that's not always the fault of the client, right? That's true across the board, but for trans people, I think it's really specific because even just riding the train, people can endure all kinds of harassment. And so really, when a trans person shows up for you, that is a gift to you, that they saw this as so important that they're willing to risk all of this obstacle course that it takes to get to the office, to get to court. We're pretty amazing people. The end. Yeah.
I can add a couple things, Laura,
Yeah.
if you
Yeah.
just in terms of following up on what she was talking about in terms of court documents. You know, I guess for a number of years, I've worked on a number of cases for people who are trans. In one of the early cases I did in Wisconsin involved a challenge to a law that was passed there banning either hormone therapy or surgery for transgender people, and you know, the state just fought to the bitter end, and we had great experts, and ultimately the Seventh Circuit struck down the law as unconstitutional facially. But in that case, the point I was trying to make was that we filed the case on behalf of our client's name, but then also listed their legal name. We just recently filed a case challenging the treatment of people who are trans in the Illinois Department of Corrections system, and I'm happy to answer questions about that. But you know, one of the things that we did is we filed on behalf of the names of our clients, and we didn't include the legal names at all, except we did in the narrative about some of our clients. We felt like we had to at least name the last name because we were concerned that the IDOC was going to go crazy about not being able to figure out who our clients are, although frankly that's crazy because we've been working with these people for a long period of time. But just look at the rules. You know, the reality is using these names that are not the comfortable name for somebody is it's harmful. And you know, in our student case, for example, that I mentioned that we filed recently, we filed a motion at the very beginning to confirm that the judge would let us use the chosen name of our client. She was going through the process of getting the legal name changed, but it hadn't actually been effective, and the judge quickly granted it. But the reality is the district then filed in the response brief all these documents, including her old name, which is really offensive. And there's so many offensive things that this district has done along the way. But those are important things, and we sometimes think that the legal rules the court rules require us to list legal names, but not always, or at least you can challenge it in various ways. So.
Yeah, I would say, I regularly file motions as well when I'm in criminal court on respecting preferred name and gender pronouns. I've not run into a single prosecuting attorney when I've presented them with a written motion citing the Chicago Human Rights Ordinance and the Illinois Human Rights Act. I've never had somebody get, not want to go along with it. Prosecuting attorneys usually, in my experience, have been pretty good at, if I explain to them and present them the written motion, I don't even have to file the written motion because they'll just go with it. And also when, I try to get to the courthouse early so I can go talk to the clerk and make sure that whoever is calling out cases knows just to call out last name if the legal first name is not affirming, because that is, a very dangerous situation when you're in a public courthouse and they call out a name that doesn't match your presentation and you walk up there, you're instantly outed to that entire courtroom. So that's, just making sure that you're checking in with opposing counsel, and that sometimes is all it takes.
And I also, on a different note, wanted to mention that there's not precedent yet in Illinois for a spousal presumption of parentage for same-sex couples. Lambda Legal does do state work as well, and we have a case right now on behalf of a non-biological mother who was married to the biological mother in Iowa in 2009, and they split up. They had a child and split up before marriage was legal in Illinois. And so that may be a scenario that you face, and we're working on fixing that right now.
And speaking of litigation that Linda's involved in, the masterpiece case, I don't know if you mentioned that at the beginning, or
that's an case.
Yeah, sorry. But I don't know that either of you touched on that. If you want to touch on that really quick as well. Everyone, I think, has heard of it, at least to a certain extent.
Yeah. I could talk a little bit about it. These, I can give you the most general view, and because I didn't write the briefs, I worked on amicus related issues. I have worked on a case here in Illinois with similar issues, but the reality is, I guess, in terms of background, is that these kinds of religious refusals, unfortunately, are quite common nationally. The ACLU's had several of them, and unfortunately, this is not necessarily the one we would have wanted to go up. We think it's absolutely that the law in Colorado should have been, was appropriately applied. This was a case in which our client went to purchase a cake and was the clients were there with one of the mothers, and so it was actually a very painful experience for them to go and be turned away from a place that they'd used before, as I recall, and told, well, we can't do that because it's a wedding cake, and we have religious views that are inconsistent with our ability to provide you a cake. And so ultimately the Colorado Court of Appeals agreed that the other side did not have these kinds of free speech defenses and religion defenses that they raised. And the case, we were a little bit surprised, was accepted by the Supreme Court. And frankly, under existing precedent, the argument that you have a free exercise or religious right to refuse to provide or to follow a uniformly applicable law is really against the cake maker. I mean, arguably they had a somewhat stronger free speech kind of an argument, because their argument was that cake making is this creative enterprise and that it affects our ability to speak through cake making. And so it was somewhat different than some of the other kinds of business service-related things that we might see. We frankly feel, I think, mostly confident that we'll win this case, but it is not. I mean, it's a bit of a challenge, frankly, and so. I mean, there are a number of other cases I'm involved in. I guess I'll just mention one if you don't mind. I don't want to go on too long here, but I have a case I've been working on which is now in the 6th Circuit, which is the federal circuit that covers Michigan, Ohio, Tennessee, and Kentucky. My client is from Michigan. We worked with the client and actually helped her go to the EEOC, the Equal Employment Opportunity Commission, to file a charge of discrimination. The EEOC, and it was against a funeral home, and what had happened was that when she came out, she was fired, basically, very quickly. And so the EEOC actually litigated the case, and somewhere into about a year and a half into the case, a anti-LGBT religiously based organization called the Alliance Defending Freedom offered to represent the employer, and suddenly there were religious bases for having fired her, which the EEOC had never heard about. The district judge found there's a federal law called the Religious Freedom Restoration Act. And the district judge found that gave the employer, the funeral home, a defense, and that it allowed them to fire her, and because that somehow offended her religion. And the fact that the EEOC was the plaintiff was important there because it is the government. It's typically the government acting that matters. And so had we filed the case ourselves, there would have been no RFRA defense. But because the EEOC brought it, it was, the defense at least arguably had some merit, although it really doesn't have any merit. But so the reality is the case was appealed to the 6th Circuit because of our larger concerns about what's happening with the federal government. We moved to intervene in the appellate court, and the court granted that motion. So we had argument, I want to say in October. I was able to be a part of the argument in the case. We feel very confident that we're going to win, but the reality is the cases can go en banc, and so I think, frankly, honestly, that's our concern. We hope that we get a win and that it stays a win and doesn't go up. So.
Thank you so much for sharing this information with us. For those of us who don't work in this area, I think this is really very interesting and informative, and we really appreciate your time. Thank you so much. Grab some of the resources on your way in. There's some really helpful guides on the table outside you can grab before you leave. And before we leave, Beth has an legislative update, I believe, and then a couple of
Yes, this won't be too long, so just a quick update. I'm Beth Johnson from Green Legal Aid. Glad to be here. One to back us update and to be here with Lark. Yeah, it's great. Thank you so much. Can you use the microphone? Yes, I could. So there's 3 bills that the CBA is sponsoring this year in Springfield that came through, 2 through the Legal Aid Committee process, and then 1 that's a carryover from last year that some of you might remember, but it bears repeating. So the first is the court fees and costs bill. Does anyone remember this being talked about last year? Right? It's out of control. There's a task force. We charge people too much money. There's no fee waiver in the criminal system. This bill addressed that, but met a S-ton of opposition last year. Like, unbelievable amount of opposition. Anyone that gets money from the system, right? And so the bill's been reintroduced this year, which is minor tweaks that gives Cook County a different scale than the rest of the state, right? It's always like that in statute. The city with the 3 million or more, or counties with 3 million or more. The sponsors this year are still a Republican chief sponsor on the House side, Steve Anderson, and then Senator Molko on the Senate side. And so that's going to work its way back through the process. Anyone that here knows former Representative Elaine Neckritz retired, and she has her own lobby firm, and her lobby firm is doing pro bono work on this bill to help it pass because they believe in it. They started it. She was one of the ones that started it, so we're lucky that she's still around advocating for this cause. The other two bills, one is the affidavit bill that no longer requires a notary for an affidavit. So that's with LRB, and it'll be filed by the deadline next week. Sponsors to be identified. And the other is the Plain Writing Act, Angela's Google brainchild. She had found, so we have an effort each year, like our laws are confusing. They're confusing for lawyers, which means they're confusing for the general public. And so while we had an individual bill last year that dealt with eviction, no longer calling it forcible entry and detainer, this is an overall bill that would just mandate that every bill that's passed has that lens on it. Plain writing. Like, let's understand what you're saying, people, right? Is that basic good enough start? Right? Yeah. A summary of that. So if you have any questions, let us know. Of course, if things come up that are of interest or impact, because we're playing defense more than offense, right? In Springfield and the General Assembly, to make sure to raise those to the attention of Angela or myself, and then people, I don't know, what do we do with it when there's something wrong with it? I mean, the CBA can speak into issues throughout the entire session. While they won't sponsor any further legislation, they still take positions, especially when it impacts the legal community and it impacts the communities that we work with. We're the ones that have to raise that up. Okay? All right.
Thanks, Beth. I was actually thinking about the fees and fines bill while, Largo, you were talking about the felony ban, because I was thinking about, oh, well, for somebody who still owes fees, they can't discharge their sentence, right? They can't end their probation, they can't until the 10 year doesn't start. So it's all intersectional, right? It all matters. So I just want to do two quick announcements we actually got today from the 7th Circuit Bar Association. So two things. One, if anyone knows of somebody who's doing a lot of really great pro bono work in the 7th Circuit, they are asking for nominations for their pro bono awards. There are flyers out in the table as you leave if you're interested in picking one of those up. Please nominate good folks for that. So that's they need those by February 16th, so that's next Friday. And then similarly, if you or anyone you know is doing a lot of legal aid or pro bono work, they have a scholarship so that you can have a membership to the 7th Circuit Bar for a year and go to their annual meeting for free. So applications for that are in April. So we'll probably send out to the full group as well, but there are flyers for that as well in the front. So I just wanted to bring that to your attention so we can get people in our community who are doing some great work recognized and maybe a little extra boost. So are there any other announcements, either things your organizations are doing or the things that we should all be aware of? Oh yeah, Margaret? Yes. What do you get?
Hi, I'm Margaret Duvall from the Domestic Violence Legal Clinic, and we are hosting a policy speech breakfast on February the 21st on changes in immigration policy and how they're impacting survivors of domestic violence. It's free, and as I mentioned, there's breakfast. You can sign up on our website, so we hope you'll all attend. We are also hiring, and we are hiring an experienced family law attorney, preferably Spanish speaking, so if you know of any good candidates, please send them our way. Thank you.
I am Daniel Masolio with First Defense Legal Aid. If you want a full day on Wednesday the 21st, We're having our monthly training from 5:30 to 7 p.m. at the Westside Justice Center, 601 South California. There's CLE credit, everything you need to make station visits.
Anything else?
One final thing, our next meeting would normally be on March 8th, but we don't have a March regular scheduled meeting because March is the month when we do our CLE. So keep your eyes peeled for information about that. It's going to be on Tuesday, March 6th from 3 to 6 p.m. Every committee sponsors one large CLE seminar every year, so this is ours. So please look out for information on that. It's going to be about breaking barriers.
If anyone,
working with clients in poverty and breaking barriers.
yeah, if anyone remembers 2 years ago, for Pro Bono Week, we did, it was like a interactive video panel presentation on, it's pretty much like poverty, cultural competency. And it's got the videos are really great. Dr. Beagle, I don't know if anyone's heard of her, but she grew up in migrant neighborhoods. She does a really fantastic job of talking about communication strategies and just, she's great, and we'll have a really great panel to kind of put a local flavor on it and people's own experiences. But that'll be a similar thing to what we did a couple of years ago. But I think so if anyone wasn't able to come to that, it'll be a good opportunity to see that panel and experience that. Thanks. But I think, anyone else? Great. All right, well, I just want to thank our panel again. You guys were